Hello. So in this video, we're going to talk about copyright. Now, first off, I'm not a copyright lawyer, but I have written about copyright. I've learned about copyright because it is related to some of the scholarly work that I do. I also may go off a little bit on the early history of copyright because I find it really fascinating. You may or may not find it that interesting, but fair warning, that will probably happen. So, what is copyright? I hear you cry. Basically, copyright is a system for protecting intellectual property. Traditionally, copyright applies to written works. But in fact, it also includes things like songs, music, videos, music videos, recordings. This video that I'm making for you is my copyrighted intellectual property. So basically anything that anyone creates using words or, to a certain extent, symbols, images to convey a meaning can be protected by copyright. And that can go from, I've got a shopping list in the other room that is technically copyrighted, because in the U.S. today, and I'm mostly going to talk about U.S. copyright, although I'll talk about British copyright for the origins of copyright as such. In the U.S. today, copyright is, if it's owned by the author, the individual creator of a particular copyrighted piece, I think it is their lifespan plus 75 years. If it is a corporate owned property, that is, if it's sort of created for hire or something like this, it is a period of 90 years, I think. I may have those numbers reversed. I meant to look this up just to refresh my memory, but I forgot. But anyway, so anything that I write, anything that I create, this YouTube video, for instance, I own the copyright to this for the term of my life. Then, again, I think it's plus 75 years. Beyond that, it's owned by my estate or whoever it is. If I create something on behalf of an employer, so for instance, animators who create something for Disney, for instance, if Disney owns the copyright to that, they own that copyright for a period of 90 years. And actually, so I'll talk more about the changes to copyright and how we got to where we are right now, but that's basically what it is. Things are automatically copyrighted, meaning you don't have to register it, although often with more formal works like books, things like this, albums, full-length movies, these things will be registered with the Library of Congress if you're in the US, or with some kind of equivalent institution in other countries. But in principle, you don't have to. The copyright is automatic. So, what is the intention of copyright? Well, the intention of copyright is, again, to protect intellectual property, to ensure that if you come up with an idea or a form of expression, that no one else can profit off of that piece without either you also profiting or at the very least acknowledging that this is your intellectual property. So, for instance, when I publish in a scholarly journal, I don't make any money off of that, but I am acknowledged as the author of that piece. So even though somebody else is possibly making money off of it, realistically, most scholarly journals run at a loss, but even though somebody else is probably, any money that is made by somebody other than me, but I still own the copyright to it. It is still my intellectual property, so nobody else could, say, reprint my article with their name on it and claim that they wrote it. It is protected to me. So typically, citation is one way that you can use copyrighted material without violating that copyright. Publication agreements are one way that people, companies, publishers, whatever it is, record labels make money off of other people's intellectual property without violating copyright, etc., etc., etc. That being said, there are significant questions about whether or not A, copyright laws do a good job at what they're supposed to be doing, and B, whether or not copyright laws are overly protective of authorial rights. I happen to fall into that latter category. I think that there are actually huge problems with the way that copyright laws work in the US today, because traditionally the tension within copyright as a legal concept deals with an author's right to make money, an author creator, whatever it is, an author's right to make money from their work versus the public domain. And the public domain is an idea that humanity as a whole, the public, should have access to things like ideas, artworks, new developments, new technologies, new ideas, etc., etc. And so we have this tension both between copyright, patents, and to a lesser extent trademarks, but also this idea of a compelling public interest to have access to the products created by humanity. And sometimes this is not that big a deal. Sometimes it is, though. I mean, one of the problems, for instance, with limitations of copyright and patents and things like this is that it can stop scientific ideas from spreading to other parts of the world, meaning that we lose potential new developments. If, say, researchers in a developing country, an impoverished country, maybe, don't have access to the scholarly journals in which the most current scientific advances are being developed, then those researchers don't have access to the most up-to-date information, which means their potential to contribute to the current debate is limited. So this is a huge problem posed by copyright and by the sort of limitations of how much knowledge can be spread. And this tension between and one of the sort of exceptions to this is fair use, and I'll talk about fair use actually in another video. But this is a structuring tension of copyright law, and in the U.S., and again, the U.S. copyright law is kind of the most important set of copyright law in the world because the U.S. just produces a massive amount of the world's intellectual property because of the number of publishers we have, etc., etc., and the reach of our publishers, our books, our magazines, our journals, etc., etc., are distributed all over the world in ways that are not as much the case with publications coming from other places. And a lot of that has to do with global power structures more than that ideas are better in the US or anything like that, which is definitely not the case. It has to do with the US has more global cultural power than anybody else, and more global economic power than anybody else. And so our stuff gets distributed in ways that stuff from other countries simply doesn't. So there's that element of it. That's why US copyright law is so important in understanding global copyright structures. Because many other countries are more or less forced to adopt US copyright standards in order to be even competitive in copyright terms, in publishing terms. US copyright law is built largely by corporations at this point. The earliest copyright laws in the US were based on the original copyright laws actually passed under the reign of Queen Anne in the UK in the early 18th century. During the 20th century especially, copyright protections expanded dramatically. one of the biggest drivers of that was actually the Walt Disney Corporation. When initially Mickey Mouse was about to enter the public domain, they launched a lawsuit and got the U.S. Congress to extend copyright, basically just so they could protect a handful of animated characters who were still making them money. The vast majority of their properties from the 20s and 30s were not making them any money anymore, but Mickey Mouse was. And that was the big thing. They literally had U.S. and, to an extent, global law changed so they could continue having exclusive ownership of Mickey Mouse. That's democracy for you under free market capitalism. But this is the sort of fundamental tension for me within copyright, is this idea that stuff is protected for authors, which is largely of benefit to corporations more than individual authors, because for the most part, authors don't make large amounts of money off of their written works long term. That's just the reality of it. Sure, there are some people, Stephen King, J.K. Rowling, whoever it is, that make massive amounts of money off of their written work, and their work will continue to sell for decades. But generally, that's not the case. You don't sell massive amounts of books. Even if you're a successful author, you don't sell massive amounts of books after multiple decades after they've been out. That's just the way it tends to work. And so this is the current situation with copyright is actually a vastly expanded set of protections for authors controlling their work, which means that we have a much more limited scope of the public domain. Much fewer works are generally available to be reproduced widely than would be the case if we had stuck with the original copyright laws. So the Copyright Act passed by Queen Anne in, I think, 1710, or passed under Queen Anne, passed by the British Parliament and approved by Queen Anne. The original terms of copyright, you had to register a work in order to have it copyrighted. You got it copyrighted for a term of 7 years, during which time no one could reprint it, reproduce it without paying you for the rights, and you could refuse to allow those rights if you wanted to. You could further. You could extend your copyright by a further 7 years at the end of the initial 7-year term if you wanted, for a total of 14 years. But then after that, the work entered the public domain. If you didn't register your work, you didn't own copyright. Anybody could reproduce it. If at the end of the 7 years you didn't register to have that copyright extended, it entered the public domain. This was really, really beneficial, actually. This was a huge component of driving the Enlightenment. Because actually, I find the story of the emergence of copyright really, really fascinating. What happened was, through the medieval period into the Renaissance, the London Printers Guild basically controlled printing in the United Kingdom. Yes, there was some printing that occurred in other places, but generally speaking, the London Guild controlled it. By the late Renaissance, in the 1600s, Edinburgh in Scotland, along with a couple of other places in Scotland, but mainly Edinburgh, developed a rival publishing industry, and they were just sort of republishing stuff that had been published in London. They were publishing their own stuff as well, particularly Scottish stuff, but they were republishing new manuscripts, new books by English authors, new discoveries by English authors, new books by continental authors that had been translated into English. They were publishing the classics that had been translated into English. All these things that had been the preserve of the London Printers Guild, the Edinburgh printers started doing, and they were doing it cheaper because they didn't have to pay sort of guild fees, and they didn't have this organizational structure that the London Guild had to navigate. So the Scots just started flooding the market with these cheap editions of these books. And incidentally, this was one of the big drivers of the Scottish Enlightenment that gives us thinkers like Adam Smith, David Hume, these sort of massive giants of liberal philosophy, political economics, empiricist philosophy, etc., etc. These great thinkers who come out of Scotland in the late 17th and 18th centuries, brilliant minds. These people are raised on this tradition of cheap Scottish printed books. And this is actually one of the great things about the public domain, in my opinion, is that when you have easy access to printed materials, more people get to read and more people get to come up with new ideas. Humanity as a whole, our collective wisdom is increased. And I, for one, think that that's quite beneficial. But that was part of the reason that Queen Anne and Parliament at the time decided to create this copyright law, because on the one hand, you had the London Printers Guild who wanted to maintain a monopoly on printing, but there was no feasible way to do that. So copyright helped protect that by limiting what could and could not be printed, who would have the rights to print certain things. At the same time, you have to protect the Scottish printers' interests, because they are a formidable economic force. And so you put the limits to copyright. 7 years, things that are registered, 14 years if you expand it. And after that, anybody can print it. And at the same time, you want to protect the public domain, because this is, again, the Enlightenment era. This idea that a widespread distribution of knowledge within society is fundamentally a good thing. And so there is that public interest, that vested interest in a public dispersal of knowledge. And so the initial copyright law is created to try and balance these three forces. And again, if you ask me, this is my opinion, I think today's copyright laws have largely focused on protecting the rights of authors, which is disproportionately beneficial to corporations more than it is to most individual authors, at the expense of the public domain, at the expense of ensuring that knowledge is accessible to everyone.